Hi, this is Josh Blackman. I am the president of the Harlan Institute, and I am happy to present the 2020 Harlan Institute ConSource Virtual Supreme Court competition. This year, we are arguing the case of Espinoza versus Montana Department of Revenue. Our first round, or actually, this is our ninth match of the tournament so far, and we have two teams from Greenwich High School in Connecticut. We have Dylan Minnie and Dylan Maloney, and David Katz and Seldon Salaj. And we'll begin with petitioners for 15 minutes. Dylan and Dylan, the floor is yours whenever you're ready.
Good afternoon, Your Honor. May it please the court that I, Dylan Maloney, and my co-counsel, Dylan Minnie, represent the petitioners Kendra Espinoza, Jerry Allen Anderson, and Jamie Schaefer. This case begs the question of whether or not the federal Constitution, and specifically the First Amendment, permits the funding of religious institutions. It does. This is because the justification that the respondents use in lower levels of this case, they use the Blaine Amendment as their justification. And the Blaine Amendment, for some history background, was inspired because many of the senators had an anti-immigrant sentiment in the post-Reconstruction era. And in order to prevent immigrants from having much say, they created anti-Christian laws, and specifically the Blaine Amendment, which prevents any funding whatsoever from going to religious institutions in general. And this is clearly a targeted law at Christians, although it does affect all religions. It's targeted at Christians because of the nature, and it wasn't written in a non-discriminatory manner. And to compare this to a recent court case, Church of Nukumu Babalu I, the city of Hialeah, the law there, which was written directly after a group, the Centurion religion, started eating making animal sacrifices, which was seen as morally wrong. So the government created a law preventing or prohibiting sacrificing animals. And in doing that, it was challenged all the way up to the Supreme Court, and that was ruled unconstitutional because it wasn't done in a non-discriminatory manner. It didn't have to say exactly that Christians can't do this or this religion can't do this. Just because because of the circumstances, it can be assumed like that.
All right, so Counselor, let me, if I can interrupt you. You talk about the Blaine Amendment and the history of these provisions, and I think we'd all agree that Senator Blaine didn't like immigrants. He didn't like Catholics. I think we all agree that in the late 1800s you had this anti-Catholic bigotry. But how should that affect our interpretation of the Montana Constitution, Article 10? How should that history affect our analysis?
Well, it affects our analysis of Article 10, Section 6, of course, but also in 36 other states to have this amendment. We need to look at it through the eyes of the Lemon test, and that this Blaine Amendment is seriously promoting excessive inhibition of religion. Yes.
I think Dylan, did you raise your hand? I'll just say Minnie. Minnie, did you raise your hand?
Yes, I did. I was just going to bring it back to how the decision of the Montana Supreme Court was to completely shut down this program, this privately funded scholarship program that was giving students the opportunity to attend schools, private schools outside of the public school. And when we look at this case overall, it's important to note who the beneficiaries of this program are.
Counselor, I appreciate that there are good people being helped, but I'd like to answer this question. When was Article 10 of the Missouri Constitution enacted?
1983, I believe.
I think it was 73, close enough, right? So we're talking 1970s. Should bigotry from the 1870s inform an amendment that was ratified, 40 years ago?
Well, that exact bigotry was brought up almost to being in the federal Constitution. The amendment only fell a few votes shy of being in our federal Constitution, and many states at that time enacted it into their Constitution. So the fact that Montana did it much later is not much of a factor, and it can certainly be seen as targeted towards Christianity, because at the lower court level, even the respondents admit that this specific program does discriminate against religion.
Well, okay, so let's just try this a different way. Weren't there members of the clergy in the 1970s who supported the Montana Amendment? I see Dylan Minnie shaking her head. How do you respond to that?
Thank you. That's a great question, Your Honor. In our research, we did come across this. We did come across both the date and the clergymen that were involved in supporting this amendment. However, we thought that the more important thing to note was the history of this amendment and how it has traveled state by state and how it has impacted states. Currently, this amendment that's prohibiting funds to schools that are of religious affiliation has a much larger effect on Christian schools and was intended towards Christian schools. In fact, in the town that Espinoza and her daughter live in, 5 out of the 5 private schools are Christian schools, and this is the case for many other towns in Montana, and it is thus directed specifically towards the Christian religion, as this is private schools are most highly occupied religiously by Christians.
So, do you think that, and this is for either one, do you think that the Montana Constitution, Article 10, is unconstitutional?
Yes.
So, Maloney, are you, Mr. Maloney, I should say, Mr. Maloney, are you asking us to then declare the Montana Constitution unconstitutional?
Yes, I am.
On its face, the entire thing is unconstitutional.
Yes.
Article 10, Section
6. Section 6, yes.
Okay. And if we Ms. Minnie, if we declare the Montana Constitution unconstitutional, would similar provisions in 36 other states also fall?
Thank you for asking that, Your Honor. Blaine Amendments are in 36 other states, as we have discussed earlier. As well, this private scholarship program is in 36 other states, yet none of these Blaine Amendments have attempted to stop the scholarship program. And I think that's where we need to start to transition into the actual elements of this scholarship program, in which this is a privately funded scholarship program that the state's only involvement is the tax credit given to those who donate to the program. And if no other Blaine Amendments in these other states are attempting to dismantle this program, it's important that we note that.
So Ms. Minnie, do you think there's any entanglement concerns with the way the current scholarship program has been structured?
Absolutely not. If we look at the Levin test, it's obviously important to note unnecessary entanglement and excessive entanglement. And if we look at this private scholarship program, giving a tax credit to those who decide to donate to this program is no different than giving any form of tax credit or tax deduction to someone who donates to a church directly. If I am allowed to donate to a church directly and receive a tax credit from the state government, then why should me donate to a private scholarship program, which is intended to aid children in an education, which is the main intention of this program? I should be able to receive a tax credit without excessive entanglement.
Well, Counselor, let me ask a question. How do you reconcile your position with Locke versus Davey?
Well, to bring up Locke versus Davey, the court in Trinity Lutheran v. Comer decided that Locke v. Davey is an extreme circumstance concerning this sort of case. The final decision decided that because of the circumstances and the facts of the case, it's an exception, because Locke v. Davey took scholarships directly from the state of Washington's funds. It didn't take private scholarships. And also, the program did permit scholarships to go to theology degrees, as long as it's not thought to cause belief in the religion itself. And at the Court of Appeals, Judge Grander also found that Locke is different from all other cases because it concerns training for clergymen, which is very different from simply getting a religious education.
Well, hold on. So what exactly, in Montana, Counselor, what exactly is the money being used for? The money being given to the schools? Do we know?
I'm glad you asked me. Upon researching the private scholarship program, we noted that only 10% of the donation program money is used for any sort of administration. 90% of that funds goes straight to the students, goes straight to their education.
What does that mean, Counselor? I'm sorry. Going straight to the education. What is it actually being spent on?
The tuition money or the administration money?
When the school gets money through Big Sky, what is the Stillwater Christian Academy spending the money on?
the student's tuition. And another
what's the no? I get that, but what's tuition? Someone's getting that money. What's it being paid? What's it paying for? How's that money being used?
Their enrollment at the school. It permits them.
And is there prayer going on at this school?
Yes, it's a.
One important thing to note is that only 50%, a max of 50% of their tuition is covered by the scholarship program. So one could make the argument that over 50% of their school time is spent on doing math or science or.
I get that. No, they have education, but I mean, is it possible that some of this money is being spent on Bible study?
Yes, it's possible, but it's impossible to monitor. And
isn't that the issue, though? Right? It's impossible to monitor. Isn't one of the concerns with the lemon test the risk of entanglement, that it's going to be so hard to monitor it that maybe the better answer is just to avoid entangling altogether?
Well, Your Honor, the best answer is to make sure that the students get the education that they need, and the court should seek a decision that allows that to happen. And the decision in Zelman v. Simmons-Harris found that by giving this, which had a voucher similar to a scholarship, and found that by giving this voucher to a large group of people, the general undertaking to provide educational opportunities to children and government aid reaches religious institutions only by way of deliberate choices of numerous individual recipients. And by just Ohio program, according to Judge Rehnquist, it brought funds directly to a wide spectrum of individuals, and the concern of it trickling down directly to the churches themselves was not as much of a concern as the students' need for an education.
Well, but Counselor, let me maybe change directions a little bit. You are all in Greenwich, it's a lovely city in Connecticut. There's another city in Connecticut that's not too far called Danbury. It was a very famous letter from a very prominent member of our founding government. You like that, Sebastian? That's actually MapQuest says. You went an hour away. A very prominent letter from Thomas Jefferson about the Danbury Baptist. How do you reconcile your position with that of Jefferson in his famous letter to the Baptists in Danbury?
Well, I think it's important to note on the state of excessive entanglement, as you were discussing earlier, that it's important to note that if we can work into the meaning behind the Establishment Clause was to remain religiously neutral, not to ignore religion in total. By remaining completely unentangled in religion, cases such as Trinity Lutheran v. Comer and Emerson v. Board of Education Ewing would thus be nullified, and a public good oftentimes will be entangled with religion. That does not mean that the federal government should completely stray away from religion, or the state government should completely stray away. They just need to remain religiously neutral in their actions.
But why can't the state, Counselor, adopt this no aid amendment to try to avoid entanglement, to try to avoid any sort of a breaching the separation of church and state? Why shouldn't states be willing to be extra cautious to prevent establishment concerns?
Thank you, and that applies perfectly to the second prong of the Lemon test. States may not aid nor inhibit religion. By completely, these Blaine Amendments are in turn inhibiting religion, and that was not the sentiment behind the Establishment Clause. It was not to inhibit religion, and it was not to inhibit religious freedom of these students, these individual students who are choosing to pursue the school that fits them best. Well,
maybe I'll ask a question to Mr. Maloney. Let's talk about we talked about Jefferson. Let's talk about his good friend Madison, right? And Madison wrote the Memorial Remonstrance down in Virginia. How does your position square with Madison's concerns in the Remonstrance?
Could you clarify his remonstrance, Your Honor?
Are you familiar with Madison's Memorial Remonstrance?
I'm not, sir.
Ms. Minnie?
I'm not, sir.
Okay, well, you have about a minute and 20 seconds left. You can move towards your conclusion. Thank you.
So the main priority to cover is that there are way more important issues concerning the students getting their education, and that being and the religious freedom and their choice to get an education is the most important aspect to protect in this case.
Absolutely. We need to take a further step back from this and look at it in its entirety. This is a private scholarship program not funded by the state that is attempting to give students an education that they feel fits them perfectly. This is a free exercise case. This is a case about the individual's choice to exercise religion through a private scholarship program. And if a child decides that a private school that may have a religious affiliation is the best choice for them, we should not be completely cutting down a program that's attempting to aid these students in achieving that goal. And it's a primary beneficiary of the situation is the child who wants to receive the education that they deserve.
Okay, 8 seconds left. Perfect timing. Thank you, Counselor. All right, we're going to switch now to the respondents. David and Seldon, you have 15 minutes. If the petitioners can put yourselves on mute, please. And respondents can begin whenever you're ready.
Thank you. Good evening. May it please the court. My name is Seldon Salaj, and my co-counsel is David Katz. We are joined today by our coach, Coach Hull. So the question that will be asked of the court today is whether or not the state government has to provide benefits to those who donate toward a religious education. The rule of law dictates that a sectarian education is not a common good. Thus, the state of Montana is not legally compelled to support it, directly or indirectly. First, I would point the justices to the case of Tilton v. Richardson. In this case, construction funds were granted to religious institutions so that they could provide funding for secular buildings which would be used for secular education. A provision was added to the law which stated that after 20 years, the buildings could be used for any purpose. They could be converted into churches or religious schools. This case went to Supreme Court, and in a 5-4 decision, the court struck down the 20-year provision, stating that if government were to appropriate funds to a religious institution, it would have a primary effect which advanced religion. This points back, of course, to the Lemon v. Kurtzman decision, which established the Lemon test. The second prong of this stated that in cases like this one, a law must have an effect which neither primarily advances nor inhibits religion, which the respondents believe this law advances religion. David?
And thank you. And that really gets to the respondent's core point, is that this case is fundamentally more Locke and less Trinity. And the reason for that is because if you look at the Trinity v. Lutheran case, a protected playground is obviously a common good. In the Trinity case, they even said, I believe, that the benefits of a new service would extend beyond its students to the local community. But if you look at the case here, the benefits of getting a religious education isn't a common good like a playground did. It isn't a common good like busing towards a school which was the case in Everson. And it isn't a common good like secular textbooks were in the Allen case. So the key difference is the fact that the common good in education lies in a secular education that preserves Jefferson's wall of separation between church and state.
Yeah, so Counselor, if I could ask a question, either it doesn't matter who. In Trinity Lutheran, the court said that you can't discriminate on the basis of religious status, right? You had a playground that applied for the rubber chips, and because the playground was attached to a church, they couldn't get the rubber chips, right? The court says you cannot discriminate on the basis of religious status. When I look at the no aid clause in the Montana Constitution, Article 10, I see exactly that. I see exactly what Trinity Lutheran said you can't do. It says the state will not give money to religious houses of worship, period. Right? A military academy can get this funding for the scholarship, but a religious academy couldn't. So, Counselor, how do you reconcile your state constitution, Article 10, with Trinity Lutheran? I think these are very hard to square together.
So, in the case that you provided, in which you said that no aid would be provided, and the no aid clause, of course, that Montana released was that aid would not be provided to a religious institution. To bring up the case that the petitioners mentioned, Church of Lukumi Babalui, which was an overt example of the government stating that a religious institution could not carry out deeds and acts which were necessary to their religious practices. It is important to note that the respondents are not arguing that the state of Montana is not providing funds on the basis of religion. It is merely that the state of Montana has an inherent interest which is historical and substantial and falls between the room for play within the joint established in Walsby Tax Communion of the City of New York, in which they do not have to facilitate the means for funding this program. The aid is, in this case, not being given based on the fact that the education provided at these institutions is inherently religious.
Well, no,
as my
Counsel, let's just put aside. I'll get to David in a minute, but let's just put aside the specifics of the scholarship program for a minute. Let's just talk about Article 10. Forget schools, forget whatever. Counselor David, how do you reconcile Article 10 with Trinity Lutheran? Doesn't Trinity Lutheran suggest that when you take such a strict separationist approach, you actually violate the free exercise clause?
Thank you for your question, Your Honor. And here's how the respondent would reconcile that. So there's a fundamental difference between denying someone funds based off their religious identity, which was what the court claimed occurred in Trinity Lutheran, and it's what occurred in Church of the Kumi Babalu Aye. So there's a difference between denying them based off religious identity and saying we're not going to facilitate your use of those funds for religious purposes.
But what does Article 10 of the Montana Constitution actually say? Do you have the text handy?
I don't have it in front of me, but it says indirectly.
Yeah, let me pull it up. So it's where is it? Here we go. Article 10, Section 6. It says, the legislature, blah, 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 shall not make any direct or indirect appropriation or payment from any public money or any source for any sectarian purpose to aid any church, school, academy, seminary, college, university, other literary or scientific institution, controlled in whole or part by any church or sect. That seems very similar to what's in Trinity Lutheran. If you were a military academy, you get the money, but if your school was based religion, a religious identity, you don't get it. How do you reconcile? I mean, try it another time, but how do you reconcile that provision of the Constitution with Trinity Lutheran?
And there's a key word in that provision, Your Honor, and that word is purpose. They don't want the funds going towards a religious purpose. So, for example, say Espinoza wanted to use her scholarship organization to go to a private school that wasn't religious, right? Something that's not Stillwater. They couldn't say no to her just because she's Christian. They'd have to give it to her then. But they can say no to her if she wants to use it to spread Christian values to her children. The state simply doesn't have to facilitate the spread of Christianity. But the state is still not allowed to facially discriminate against someone because they're Christian. It's the difference between identity and practice, Your Honor.
Under this Constitution, could Montana give money to a religious school to pay for science books or history books?
So in the case that you've mentioned, the short answer would be yes. But where the respondent would argue is that in order for the state to determine the use of this funds, the purpose of this funds, as Justice Blackmun stated during the petitioner's argument, how do we really know where these funds are going? Is it possible that these funds could be used for the sectarian aspect of this religious school? And the short answer would be yes. And according to the Lemon test, which states that the government must avoid excessive entanglement with religion, under that third prong of the Lemon test, in order for the government of the state of Montana to decide that the state, in this case, is not using those funds for any sectarian purpose, including Bible study or prayer, it would cause a degree of micromanagement on the behalf of the government.
So you don't even think Montana could give money to a religious school to pay for like science books or math books? Is that your position?
No, Your Honor. Our position is essentially what my co-counsel was getting at. So if you were giving them a book in science, so if I gave them, let's say, a biology textbook, obviously that textbook is going to be used in a biology class, and therefore we can be sure that biology is a secular purpose.
Sure?
I think it's in the national curriculum.
Are you sure? What if the teacher uses it to discuss why creationism is better?
I mean, if the biology textbook was teaching evolution, I don't know how the school would cover evolution.
They say that this book is wrong. Here's an example of a wrong argument. I realize I'm being difficult with you, but the way I read the Montana Constitution, I don't think they get a biology textbook.
I think you could. It's because the reason a better example might be like a math textbook. Biology is kind of a fishy subject with religion, but if it was like a physics textbook or a math textbook, or I'd even extend it to a biology textbook, though that is a gray area. I'd agree. But just to say a math textbook, there's not really much religion to be taught in a math class, so therefore you could ensure its secular purpose.
But do you think that would be permissible under the Montana? I mean, I'm just reading the text. It says,
I do.
For any sectarian purpose, or to aid any school controlled in whole or part by a church. The key word there is or, right? It's sectarian purpose or to aid a school. So I don't think you can get any funding of a church at all. Yes, Seldon.
So I think if the funding, as in this case, is going directly to the school, the state of Montana is compelled legally under their own constitution to not support it. But under the child benefit theory pioneered in Cochran v. Louisiana Board of Education, a biology textbook or a math textbook.
But let's just go back though. I realize we're getting bogged down by textbooks, but your friends on the other side argue that this is unconstitutional in its face, and that it can't be reconciled with Trinity Lutheran. I think you'd agree that Montana went beyond what's required by Lemon Test, or do you think Montana's? So maybe they went too far. Maybe they played too much with the joints, and we're left with a violation of free exercise. I mean, what's the best defense you have of the Article 10?
I think the constitutionality of the Blaine Amendment as a whole isn't necessary in a ruling on this case, because if you take the portion of it that comes before the or there, and you're looking at the part where it says, that they are allowed to not fund sectarian purposes, that's really where they got the standard that said that this entire program shouldn't be allowed. And that part of the standard is definitely constitutional under the federal constitution. I think the rest of the Blaine Amendment, there's no need for the court to rule on it in this case. It's not applicable.
All right. Let's move on a bit. At a few points, you both have mentioned the Lemon Test, which was, I think, almost 40-something years old now. Do you think the Lemon Test represents the Supreme Court's current approach to Establishment Clause cases? Is the Lemon Test the test that this court uses? Go ahead.
I believe so. I think that in a case like Trinity Lutheran, which is, of course, a more recent case, you can still see traces of the Lemon Test. The Lemon Test says, of course, that first, the law must be facially neutral with respect to religion. Second, it must have a primary effect which neither advances nor inhibits religion. And, of course, third, a government must avoid excessive entanglement with religion. If you look at cases like Trinity Lutheran, in which funds were approved to go toward a religious purpose, it doesn't violate any prong of the Lemon Test.
Well, but did the court decide Trinity Lutheran on Establishment Clause grounds or on Free Exercise Clause grounds?
So the courts decided Trinity Lutheran on the grounds that due to I believe it was on free exercise. They said that it's because this benefit it was kind of playing in those play between the joints between the establishment and free exercise. It says, okay, there isn't an establishment clause concern here because it's going towards a secular common good. And because the fund this is generally available to everybody else, that is a free exercise concern. Therefore, it is unconstitutional. So they got past the establishment clause concern and then moved into the free exercise issue.
So let's talk a little bit about Zellman versus Simmons-Harris. How do you distinguish the voucher program in Zellman versus the Big Sky program in Montana?
The biggest difference is that, and this is actually a major part of the respondent's point, is that Montana, if they wanted to fund this type of religious schooling, right, the Zellman versus Simmons-Harris case says that they are allowed to, but they're also allowed not to under their own Blaine Amendment. The major issue with Zellman, the difference is that the state of Ohio does not have a no-aid clause like the state of Montana does. So therefore, the only thing that it proves is that there's no federal establishment concern. But the state has their own inherent interest in their own establishment concern. And this interest is rooted in the history of Montana and the people of Montana. After all, if you go back to the Constitutional Convention in 1973, Delegate Conover, who's representing a church at that convention, said that if we cannot support our private schools, then it's our fault. We are the ones that are running it, and we don't want anybody to interfere. So as Delegate Burkett said, the issue of church and state is a very emotional one for the public. So because of Montana's own establishment concerns, they are able to strike down this program. It doesn't have to do with the federal establishment precedent.
Well, I think that maybe in the 70s, members of religious groups were opposed to this, but religious schools today don't take that position. In fact, Deborah Espinoza and her family is very much affected by this ruling. Doesn't this amendment, doesn't Rule 1, the Amendment 10, actually harm religious schools in Montana? Good.
I wouldn't.
I would assume, David, you can.
No, you go. There was last.
Seldon, go ahead, please.
So I would personally say that if we were to go down this, According to Madison, quote, the metes and bounds which preserve each department of power in our nation must be invariably maintained. And in this case, he was writing a letter in refutation to a bill that was proposed in Virginia, which stated that Christian teachers would be supported by a tax payable
Is that the memorial remonstrance you're reading about?
The people of the Commonwealth.
Is that you're reading about the memorial remonstrance? Yeah.
Patrick Henry proposed a bill to the General Assembly of the Commonwealth of Virginia, and in opposition, Madison said that the metes and bounds must be invariably be maintained between each department of power, and he cited that religion itself was a department of power, and that government and religion must be separate, and secularity in government was essential to the continuation of our free nation. So according and in line with founders' intent, I believe the First Amendment lays out the fact that we need this secularity. At the end of the day, there has to be a strong line between what is religion and what is government. So the affairs of the state of Montana, and though this issue might affect people like Kendra Espinoza, the quote that was provided by my co-counsel shows that the bounds between religion and government is important to those in the religious field.
You have about 20 seconds left, counsel, if you want to just wrap up. I'm sorry.
Yeah, so if a religious institution was, of course, subject to public funds, they would also be subject to public regulation. And I think that according with our founders' intent, it's important that we maintain these bounds. And the state, of course, in this case, should not be compelled to provide benefits to those who privately donate toward a religious education.
That was a very long sentence without any commas or semicolons, but I appreciate it. Thank you. All right. Can the petitioners come back on the line, please? I see one camera. I see Ms. Maloney, Ms. Minnie. All right. You have 5 minutes rebuttal. You can begin whenever you're ready.
Thank you. I would first like to address a very important point that the respondents brought up, which was that you don't know exactly where the money is going. And if this truly was a case for setting precedent, then we would be nullifying the decision of Emerson v. Board of Education, Ewing, and Trinity Lutheran, as who's to know if you could make this case for a while. Who's to know if an Emerson v. Board of Education, if on the buses, the bus driver was saying prayers or singing hymns, who's to know directly where that money is going? There's no religious affiliation. In Trinity Lutheran, the students could be writing the 10 Commandments on the chalk on the blacktop. You don't fully know every single time that you give money to a religious institution. And that's why Justice Thomas stated in his conclusion of Trinity Lutheran that burdens on religion in order to avoid entanglement were not to be allowed, as it is more important to aid the children in this situation than to try to completely avoid any sort of entanglement.
Well, Ms. Minnie, let me ask you a question. Can't we distinguish Trinity Lutheran on the grounds that we're talking public safety, right? We're talking about putting rubber chips on a playground so kids don't scrape their knees. Isn't there a difference between rubber chips to keep kids from not scraping their knees and paying for teachers who might be praying in class? Isn't there a difference? Can we draw that distinction?
Well, I necessarily, personally, I wouldn't draw a distinction between a child getting hurt and a child not receiving the education that they feel that they are entitled to. Education is something that all Americans value as very important for the children. And
But the risks of injecting religion are much greater in a classroom than on the floor of a playground.
But where are we going to draw the line with that? We need to be very clear that while they might be greater in school than on a playground, there's still a risk of religious entanglement, of religion being discussed in this area. Dylan?
Yes, and that being said, in order to judge what is happening, as Justice Blackmun, you spoke about with the respondents, the lemon test is not exactly a sufficient judge of whether something is constitutional or not. It doesn't successfully evaluate the purpose of something that's happening that's religiously affiliated. And the main purpose of this is to let the kids get education. The main purpose in Zellman was to let the kids get their education. So by taking that away, yes, there's a clash here between religion and a student's right to education, but there's much more harm by taking away their education than
well, I get it. Ms. Espinoza will definitely be harmed by this, but why can't Montana take these extra efforts to avoid risks of entanglement? Your friends on the other side said that all these preachers and members of the clergy favored this. Why why can't Montana go above and beyond what's required by the Establishment Clause to ensure we don't have this sort of entanglement? Why is that not a permissible policy choice the state can make?
Well, Your Honor, they're going too far, and that's the problem. They're basically cutting out religion entirely, and that's not good even in the eyes of the government to completely purge religion. That's not a good thing. And the decision at the state Supreme Court of Montana at this level decided that, yes, the program was unconstitutional, so they shut down the program entirely. But that's not a good solution because it still takes away from kids. And what many respondents and people in the opposition propose is that we take away just the education for the kids that want to go to religious schools. But by shutting down the entire program, you're taking education away from so many more kids, and that's causing a much bigger problem than is coming up.
Okay, and you have about a minute left, Counsel. You can wrap up.
Additionally, the sentiment behind the Establishment Clause with religious neutrality, and by creating this Blaine Amendment in Montana, this isn't religiously neutral, it's religiously targeted, and it inhibits religion. And thus, it's not stepping above and beyond to disentangle from religion. It is completely, it's more of an attack on religion than it is a neutrality. And as my partner was bringing up earlier, the bigger issue here at this case is the students. This is a free exercise case. This is the students' free exercise to attend a school that they think fits them best. Trinity Lutheran was both a free exercise and an equal protection case under the law. Equal opportunity for these children to be seeking the education that they are entitled to and they feel fits best.
The final point I'd like to bring up before we run out of time.
And your time is up. It's okay. It's okay. Thank you, though. I appreciate it. Okay, we have... I'm sorry, that was mean. I'm sorry. My thing went beep the second before my time is up.
Okay.
All right, I think we have... I'm sorry, that was bad. We have 5 minutes left for the respondents for their rebuttal. Counsel, you begin whenever you're ready.
So the first thing I would like to address was the initial comment and the initial question proposed by the petitioner. They stated that the question was whether or not the court would permit the funding of religious institutions. We argue that this is an overgeneralization and it is too simplistic. This is not whether or not this being the funding of religious institutions, it is whether or not this funding is allowed to go toward the sectarian aspect of this religious institution. Under that line, my co-counsel will continue and talk a little bit about where we are in terms of when funding is acceptable and when it is not.
Yeah, and to get a little more specific about what exactly the question is it's really more, is a state government allowed to say, no, we don't want to fund this aspect of religious education. We do not want to fund a child's religious education. The petitioners have stated that this is really a case that's talking about, the children aren't going to get education, and that's the common good at hand here. However, there are public schools within the state of Montana, and Espinoza is still free to send her students to Stillwater Christian High School. And I don't think anyone would concede otherwise. And she's still...
Right, but the counsel, if I can interrupt you, but the state is denying her this benefit solely because she seeks to have a religious education. And again, that's Trinity Lutheran. That's why if she was sending her kid to a military academy, there'd be no problem.
The only thing that they're really denying is they're denying a tax credit for her choice to donate to a scholarship organization. They're not saying the scholarship organization can't give her money, and they're not denying her choice.
But it's denying a benefit based on religious status. Like, think in Missouri, they would have got the rubber chipped, but they didn't because they're religious. Here, the scholarship organization might get the tax benefits, but they won't because they're religious. I see just this parallel between the two programs.
Well, the people who are getting the tax credit are those donating to the scholarship organization. And the difference here, and I think it's really a key difference to get at, is the fact that, and you said it perfectly earlier, is that the fact that the money here could be used for religious education. We simply don't know where the money is going, right? While the money in Trinity Lutheran was definitely being used towards the playground. The money in Everson was definitely being used towards busing. The money in Allen was definitely being used towards secular textbooks. But if you give the school money, you don't know where it's going. And under the ruling in Nyquist, if you don't know where the money is going, you don't have to give it. And
so I'm sorry to interrupt, Counselor. Could Montana restructure this and say the scholarships can only be given for, I'll use your example, math textbooks, right? Physics textbooks. Could Montana structure the program that way?
if, of course, if the funds were being guaranteed, if there was a means such as in Trinity or in Everson where you knew the explicit purpose of what was being funded, then the religious school cannot be discriminated against inherently.
But wouldn't Article
defensive.
10 still prohibit that funding because it's in aid of a school? It's not just for sectarian purposes. It's in aid, period. Like, how could Montana even have that sort of modified policy? Would it even be allowed under the state law?
Well, once again, that hypothetical here isn't at play. If you look at the federal,
Of course it's not. That's why it's a hypothetical. But okay, go on, Counselor.
If you look at the federal precedent, then what it would say is that yes, Montana would have to give the money to them if they were going to use them for science textbooks. But here, if you're asking if there's a way that we could alter the program to make it permissible under federal precedent or to make it that Montana would have to give the money,
Okay.
There's no real way to split the baby, because if you're going to give people the school tuition money, you would then have to tell them where they can spend that tuition money. And the respondent holds that that is excessive entanglement of the government with religion, which would be violation of the third prong in the Lemon test.
All right. Counselor, you have about a minute left, but Seldon, you can proceed.
Yeah. So kind of to conclude points that the respondents have outlined throughout our argument, we believe that the state of Montana should be not legally compelled to fund the sectarian aspect of religious education. If the funds are going toward a common good, the respondents, of course, believe that the state of Montana is compelled and is not permitted to discriminate based on this religious status. However, as established in Board of Education v. Allen, and in just looking at the mission statement of the Stillwater High School, which is to, quote, equip students with the tools for learning through a Christ-centered education, we believe that a religious education, as established in Board of Education v. Allen, is pursuing two goals: religious instruction and secular education. As long as religious education is not guaranteed a common good and is not classified as a common good, as is the precedent in the Supreme Court, we believe that the state of Montana is not legally compelled to fund it.
Okay, 5 seconds left, right on time. Okay, thank you so much. That brings this round to a close. We will post this video on YouTube later today. We will also send your scores around at some point next week. We don't know exactly when. I think we still have another 4 rounds to hold on Monday. It's going to be a 4-hour block, but it's going to be fun. And I do think we'll have at least another 8 teams advance. Hopefully, maybe one of you will be able to advance to the next round. I want to thank you all. This was not easy. The questions that I ask you are hard. I interrupt you. I am rude. I'm maybe a little bit mean, maybe too mean. I'm sorry. But I try to simulate this as best as I can to give you a sense of what an oral argument would actually look like. And I can tell you, you did as well as any lawyers you'll see in a federal court of appeals in this country. I mean that sincerely. I really do. Most lawyers can't handle the sort of feedback that I just threw to you. So you did very well. I think I could also say that the amount of knowledge you have, both of cases and history, is quite deep. So you should be very proud. I know Coach Hull trains you well. He did a good job again this year. And you should all be very proud of yourself. So congratulations. I will give you the emoji round of applause, because that's apparently how we convey emotion in the age of Corona. Do you have any questions for me or for Sebastian that you'd like to ask?
No, just thank you so much for the opportunity. This is like a great program.
Yeah, I'm sorry. I'm sorry?
My sister did it too, and that's kind of how I got involved.
Oh, I knew the name Minnie looked familiar. What was her first name?
Lucy. She did it with Arjun, I think.
Yeah, about 2 or 3 years ago?
Yeah.
I remember that. I knew that name looked familiar. Well, please tell your sister I said hi. Is she in college now?
Yeah, she's at Dartmouth.
Oh, well, that's a famous school with a Supreme Court case named after it. Make sure you tell her I said hi, okay?
Okay, great.
Okay. Any questions from the other 3? Anything else you want to ask?
All set.
Thank you.
All right, Sebastian, anything you'd like to add?
No, I mean, adding on to what Justice Blackmun said, this is obviously a very difficult and complex case. There's a reason, A, that it's in front of the Supreme Court to begin with, and B, that we decided to moot it. So there's obviously a lot of intricacies that Justice Blackmun decided to press on you. But also I'd like to say, and I think I said something to this effect, to another team yesterday, like looking back on when I was in high school, which wasn't that long ago, There was no way in heck that I would have done something like this or done nearly as well as either of you teams did. So you should definitely be very proud, and I think your futures are all very bright.
Yes. Aaron, anything you want to add, my friend? I'll take that as a no.
I got to go live. No, I'm very proud. I'll make a public apology about Madison, and I'm cringing that I don't have that handed out to everybody on a mimeograph, as it were, for my generation. But very, very, very proud. These guys are doing incredible things under very challenging circumstances. I could not be prouder, and I want that stated for the record. So thank you very much, both of you, for hosting this. It's inspiring, and it gives them an anchor in the storm. So thank you.
Oh, we try to be anchors in storms. I like that. All right, I will bring this round to a close. Thank you so much, and have a wonderful evening.
Thank you.
You too. Thank you.